we are very fortunate to have with us today Mr. Dhiren Sharma, advocate, and Mr. Deepan Kumar Sarkar, advocate. Mr. Dhiren Sharma is our subject matter expert today on the topic of third-party assets, rights, and responsibilities. So we chose this topic because the firm has a considerable practice in this area, and the jurisprudence is evolving. So we would like to hear from Dhiren Da and Mr. Deepan Sarkar on this topic. So, and Deepan, thank you for being kind to moderate this session for us. And it is a pleasure for me to welcome you as the moderator for this session. And dear audience, just by way of an introduction, I would like to tell you some things about Deepan Sarkar. So Deepan is an advocate and an author and is also a lecturer. His practice spans across constitutional, commercial, and arbitration matters. And he regularly appears in various state high courts, Supreme Court, NCLT, and NCLAT. His clients include corporate entities, MNCs, police departments, and allied bodies of United Nations. He has also been associated with extradition matters in UK, where he has been in the proceedings before the Commission for the Control of International Police, Interpol. Deepan regularly writes for leading publication and delivers guest lecture at various government departments that train bureaucrats, including Administrative Training Institute, Northeastern Police Academy, Regional Institute of Correctional Administration. Deepan, I think I have been able to do some justice to your extraordinary credentials. And over to you to welcome our guest lecturer, Mr. Dhiren Sharma, for the evening today and take us through this interesting session on third-party assets. Thank you.
Thank you, Khushbu. Before you start, may I say a few words? Yes, please, sir. So thank you, Khushbu. So by your introduction, Dhiren, Khushbu is our Chief Strategy Officer. She sits out of Delhi, in the branch in Delhi. Nice. And so, the idea of the topic was mine. It was something which was irking me since IBC came into force, that I find it most inequitable that an asset of a third party should be subject to fetters imposed by a resolution plan. I know that there are balancing interests, that you are balancing the larger objective of the legislation, which is resolution, with the private interest of a third party whose property right is can be right to receive money, the right to property itself, where right to property is being deferred or kind of obfuscated for no fault of the owner of the third party, the third party owner. That is when I called you, and here, Dhiren, you're not arguing one side. You'll be explaining both sides. You'll explain both sides, and here, Deepan, you're not a counsel. You're the judge and the jury. So over to both of you.
Thank you, Khushbu. Thank you, Devanjana. Good evening, everyone. I welcome you all to Fox&Mandal's third continuing legal education session. CLE, as it is being called, is an interesting initiative dedicated to the promotion of continuous learning within the legal profession. Anyone joining the legal profession will have heard from their seniors and mentors that practicing law always equals learning the law. It is a lifelong endeavor to keep learning, for the law is both endless and its scope infinite. The CLA is yet another addition. This is the third session and an important one, for the issue to be addressed is at once crucial yet unresolved, illuminating yet full of gray areas, and necessary yet controversial. The issue is resolution plan, third-party rights and assets. A prosperous country will have successful businesses. A prosperous country will also have a robust rule of law. For businesses to prosper, they must be aided by a rules-based yet pragmatic legal regime. Now, this assumes importance, particularly when, due to various reasons, a successful business suffers a reversal of fortune. Now, after all, businesses are a human endeavor and humans are fallible. At this juncture, it is only a robust law that can intervene to revive this business through effective measures, staying within the confines of legality. These measures will not only revive temporarily, but sustainably and permanently. After several failed attempts at providing for an effective insolvency and bankruptcy regime, which led to piecemeal solutions, problems through half-hearted measures, the Insolvency and Bankruptcy Code 2015 was enacted to consolidate and amend the laws relating to reorganization, insolvency resolution of corporate persons, partnership firms, and individuals in a time-bound manner for maximization of the value of assets of such persons in order to promote entrepreneurship, to ensure availability of credit, and to balance the interests of all stakeholders. This was meant to be that robust law, and the corporate insolvency resolution process, or the CIRP, was the answer. However, as it happens all the time, every law is perfect till it is practically applied. That is when the problems start. The CIRP is no different. To ensure revival of the corporate debtor, how far can third-party rights and assets be interfered with? In the garb of insolvency resolution, can the resolution professional encroach into third-party rights and assets for the benefit of the corporate debtor? If so, how much? To what extent? For instance, if the corporate debtor is a lessee, how far can the landowner's rights be prejudiced? How do we balance someone's right to property with the obligation to revive a business? Are the scales tilted? If yes, in whose favor? To help us understand this thorny issue, which does not appear to have been conclusively settled till now, we need the erudition of Mr. Dhiren Sharma. I will not waste your time by introducing Mr. Sharma to the world of commercial litigation. If you are attending this session, you will know who he is. An LLB from the Department of Law, University of Calcutta in 1995, who joined the chambers of Mr. Justice Shonjit Banerjee in 1997, Mr. Sharma is a lawyer par excellence, a regular at NCLTs and NCLATs throughout the country, as also various high courts and the Supreme Court. He is the brains behind many a legal battle, especially those with high stakes. His advocacy has already contributed to the interpretation and evolution of the IBC, which is still at a nascent stage. He has helped shed light on many a gray area when it comes to the CIRP, and I hope he will do the same with today's topic. I'm not wasting any more time. Let us hear from Mr. Sharma himself. Thank you.
We are live on LinkedIn, we are live on YouTube now, and there are participants now, at least 28, 29 people, but of course there are multiple people sharing screens. Over to you.
First of all, and then thank you, Mr. Mandal and Mr. Sarkar, and thank you, Khushbu, for giving me this opportunity. Now, the topic for the day is a very, in the sense, it's a very nascent topic in the sense that then a resolution plan comes up for approval before the NCLT. The idea behind this is that the corporate debtor for which the commercial insolvency resolution process has begun, which the balance in the IBC is such that the legislature intention is that the corporate debtor should continue to run. And if the business of the corporate debtor is disrupted by reason of the concerned asset being taken away, or if the corporate debtor is not allowed to use the particular asset, the purpose of the resolution will not be there, and ultimately it will be visualizing that the corporate debtor may not be able to run, even if the plan is approved. But the problem which we are now facing is that there are many assets which can be categorized into different categories. Some assets which are core to the business of the particular corporate debtor, depending on which business the corporate debtor is engaged in. Secondly, are those assets which may not be that critical to the working of that particular corporate debtor. So this is a factual equation which varies from entities to entity. For example, if the corporate debtor is in the business of manufacturing or having a manufacturing unit or a plant set on a land, like Mr. Mandal has indicated, leasehold. So for that particular manufacturing unit of the corporate debtor, which is situated on a factory land, and the land does not belong to the corporate debtor, it may be a lease property or it may be property given otherwise than in form of an ownership. So if in case of those particular scenario, it is the attempt of the resolution professional is to ensure that the factory is in a running condition. Now, under the code, if the resolution professional is able to give a successful resolution plan, I'm not counting on the number of days, he's getting some enhanced fees. The percentage of fees which he's getting will increase depending on the plan being successful or unsuccessful. Secondly, depending on the period which he has taken to have the process concluded. So the object of the professional is always to enhance the compass or the scope of the asset of the corporate debtor. So the first thing which he is doing as per the act is to prepare the information memorandum. Now, in the information memorandum, the most important thing is what is to be included in the information memorandum. Here, the main issue is when the information memorandum is prepared, who are privy to this document and who are not privy to this document. Now, as per the prevailing law, when the information memorandum is prepared, it is only the banks who are part of the committee of creditors or the other lenders who are part of the committee of creditors and the professional himself. And the valuers who the professional may have engaged for the purpose of valuing the asset. But most of the cases it is happening that the contents of the information memorandum is not shared or is not available to maybe the actual owner or the person who is going to be the person most affected by the inclusion of that particular asset in the information memorandum. So the trigger is the information memorandum, which is also known as IM. Now, if the information memorandum says true, and next step is the RP will then, the professional will then invite the expression of interest, and then the intending participants will come as a prospective resolution applicants, and they will see the information memorandum, and then they will request the professional that they want to inspect the assets. The asset is inspected, the documents are shown, but in majority of the cases which we will see from the various judgments which have come as of now, the consent or the knowledge of the owner who may have entered into contract with the corporate debtor earlier before the commencement of the CIP is not there. In most of the cases, he is not even aware. The same thing was also this particular aspect of third-party assets, which we known as TPA, can also be seen from another context when we used to, in the old regime of Companies Act 1956, when there was a scheme, when we used to scheme of demergers, but involving a property of company A being demerged to company B, known as the resulting entity. In some cases, what we used to do earlier, or the schemes used to include a particular clause that even if the property is a rented one or a leased out one, that would be included in the schedule of assets, and it will go from the demerged entity to the resulting company. And then after the scheme is sanctioned, the schedule of assets and the certified copy of the scheme is uploaded with the Ministry of Corporate Affairs. Earlier it was, now it is INC 28. Then it has a binding effect and becomes in rank. So it binds everyone and each one, even if he, she or it is not party to the proceedings, even if he, she or it is not aware of those proceedings, but it becomes binding. in that particular aspect, the analogy behind this is still carried on in the form of this in this IBC. But here also, if a particular asset is there in the information memorandum, there is no provision in the code directly, which is a codified code, that you have to inform or take consent of the owner of the asset if the corporate debtor is not the owner in the books of that. That means that if in the balance sheet of the corporate debtor, the particular asset is not shown as the asset belonging as ownership to the corporate debtor, in that case the code is silent. That what should be the procedure, whether the consent of the owner has to be obtained and how the consent has to be obtained. In the old regime of 56, the parent case was the general review judgment of the Supreme Court. When the tenant in that matter came and opposed the scheme, the Supreme Court said no, nothing doing. It has to be expunged from the schedule of assets because the owner said, I have not given my consent. So I cannot, the change of tenant is without my consent. Earlier the tenant was A, now the tenant has become B. I did not give my consent to kindly delete the assets from the schedule of assets. So this was the practice when we used to under the old 1956 Act. Now, if we come here to the Insolvency Code and the section which is, there are only two relevant sections. One is section 18 and the other is section 25. Now, if in the definition clause, asset has not been defined in the IBC. Now, if we come to section 18 of the Insolvency Code, 18.1 subsection, 18.1 clause F. It is a duty of the interim resolution professional who is appointed after the CIP commences. Now, 18.1 F has reads to say that to take control and custody of any asset over which the corporate debtor has ownership rights as recorded in the balance sheet of the corporate debtor. And if you go to Roman and the explanation below, so 18.1 F says that the IRP has the full power to take control and custody of any asset over which the treaty has ownership rights. So this will show the ownership right can only be if there is a deed of conveyance or if the CD is a recorded owner as per the title of rights. So ownership right under the meaning of 18.1 F does not contemplate tenant or a lessee, because that right is under the Transfer of Property Act. The ownership will only be if there is a deed or registered deed of conveyance having been executed. Even if a lease is for 99 years or 80 years or 75 years, technically it does not become the owner. Now, if we read the explanation below 18.1 F, which has now been recently interpreted by the Supreme Court in a recent judgment, the explanation says that asset which is defined in 18.1 F will not include assets owned by third party in possession of corporate debtor held under trust or under contractual arrangement, including bailment. So by giving the explanation, the legislature intention is that same which if we see the general radio principles of Supreme Court, that this asset will not include assets which are under contractual arrangement, in the sense that if there is a contract between CD and the owner of the asset, or if asset is used under some arrangement, some other particular contract, then those assets will be excluded for the purpose of the IRP taking possession. Now, here one of the issue which will come or which has come in many judgments is that if a particular land over which the factory of the corporate debtor is there, if the land is leasehold and it is not, this corporate debtor name is not recorded as an asset in the books, but the corporate debtor has been using this asset, which may be a land for many years, 40, 50 years. Now here the Supreme Court, the recent judgment which has come by the Supreme Court in the Victory Iron case, if the reference of the judgment is 2023, 7 Supreme Court cases 227. very recent judgment of March 2023. Here the issue was the corporate debtor was the owner of the land, and corporate debtor had given this, given the development right of the land to the particular entity. Now the developer, which was in this case, had gone into CIRP. Now, when this developer company had gone into CIRP, the resolution professional of the developer company had taken control of this land, and because this land was given to the developer for development, but the asset was owned by an entity known as Energy Properties. Now, when the issue came up there, whether this asset, whether the development right can be described as an asset of a corporate debtor. Now, corporate debtor is not the owner of the land. The owner is another person. Corporate debtor was given as only the development right for the land. Now, here the Supreme Court has said that the development right will be considered to be an asset of the corporate debtor. And in this context, if you can just go to 18(1)(f), Roman 3 and Roman 4. Roman 3 uses tangible assets, whether movable or immovable, and Roman 4 mentions intangible assets, including intellectual property. Now, development right in that sense is not a tangible asset. But if the land is not available to the corporate debtor, then corporate debtor will not have any land to develop. So the corporate debtor, if it is put into resolution, there will be no business left, because if it does not have the land, it cannot develop the land. So here the fight was whether here the owner of the land wanted to take back the land. He's saying that not that my contract for this age, he has gone into CIRP. I don't like the face of B. Why will I allow another person to develop my land? I had some equation or some understanding with A. Why will I give my land to developer who I don't know who will come in the place of A, and after the plan goes through or when the CIP ends. Now, as of now, this judgment is holding the field that the development right, this was only in respect of the development right. So the owner of the land, irrespective of his not liking the present developer who may come through, he has no option. He has to continue to offer his land for the upcoming or new person who will be the SRA. At presently, in this matter, the plan approval is pending. Some one or two SRAs have come whose plan approval is now placed before the adjudicating authority. Now, if the plan is ultimately approved, the corporate debtor will have to function as a developer and go and finish the development work.
But here, Mr. Sharma, I had to, as a review, because it's not a, it's a conversation.
Yes,
if you allow me, I have two sub questions to this main topic. That A, what if there are breaches as on that date, and which breach, it could be any breach, allows the owner of the land vis-a-vis the CD/stroke developer to terminate the agreement? Question number one. What has the Supreme Court said on that? What if there was a
Can I answer this question before we go to the second question? Now, in this particular agreement, there is a termination clause, but the termination clause before the CIP had commenced, the termination clause, the termination right or the termination clause were not invoked by the.
Okay, so does it mean, therefore, that if the termination event has arisen, event of termination has arisen, and the agreement provides that if there is such an event of termination, including that you being, an application being filed against you under CIRP, for your CIRP under IBC, that entitles the owner of the land to terminate. Will that termination be upheld? And then, then will I be taken, will my right of termination be taken away? And the new SRA continue, notwithstanding that the event of default has happened?
If I can explain it, that if the termination right has not been exercised by either party, it can be terminated by A or B. There are two contracting parties, the owner and the developer. Now, if the developer or the owner does not exercise the right of termination before the CIRP commences, that is when the order of admission is passed, the termination, the right to termination is suspended because once the CIRP starts, the moratorium commences.
Fine.
After
So if
the
it has
whole
been,
thing,
if it has
after the
been,
plan
if it has been
done.
done, if it has not been done before, then it cannot be done
Cannot be
during the
done.
CIRP.
Yes.
Next question is that what if, and then can I terminate after the CIRP ends?
They
Or can
after,
or can the event which gave rise to my right of termination be washed away?
yes. Now, it means what is happening in these cases that in most of the resolution plans, there is a white clause inserted in most of the plans that all earlier agreements, contracts are novated. Now, it
No,
depends.
novation is one thing.
Cancel also. It depends on the particular plan in this matter or any matter, what provision in the plan they give regarding the particular development agreement.
Has there been any such plan or any judicial pronouncement which changes the terms of a contract?
Yeah.
Of a third party owner?
Or takes away my right to terminate. It's as simple
Or
as that.
changes it?
Same, any
There
matter.
are most of the
Has
plans.
it come up with judicial adjudication? And so what are the courts saying?
No, most of the most
Because
of-
we would like to advise our clients either way. Today we were in negotiation for the owner of a big developer who wants to develop a project. I just come from that negotiation meeting. The developer has said that no, I don't agree to this clause. One of the clauses which had been put in from our side was that if there is a proceeding under this IBC, a mere pendency proceeding is a right of termination. I can terminate. Suppose I don't terminate. I didn't know. But a right of termination has arisen. I could have terminated. Even though default has arisen. I can't do it during the period of moratorium. I agree because of legislative interdiction. What if post that resolution plan, can I exercise that right of termination?
Yes, here you have to see if you come to the section 30, what are the ingredients of the resolution plan? Now, if you come to section 30, subsection 302, subsection D and E. Now, in most of the plans are now including a clause that the agreement or contract which are subsisting when the CIRP had commenced, and if those agreements continue post CIRP, then it depends on the incoming SRA to take steps in accordance with the agreement.
Oh, so you're saying in accordance with terms of the agreement?
Yes,
So therefore you're saying that so far there has been no judicial pronouncement?
yes, because this clause D and E says that the plan should not contribute any provision of law. So if the resolution plan provides for an inbuilt mechanism that because the order passed approving plan in order in then. So if a clause provides that all this existing agreement stands cancelled, so that
Or contrary, stands extended by 30 years.
so that will be contrary to
Which law?
that will be because a contract is between two parties.
So contrary to contract.
Contrary to the Indian Contract Act. So in that sense, because the one party to the contract has not got the opportunity to express his or her wish, and the terms of the
That's
contract.
the reason for clear judicial finding that the terms of a contract cannot be varied without the consent of the contracting party.
Yeah, the purpose of the object of this, the code is saying that if there is nothing contrary, the IBC orders are in rem. They will prevail over other laws provided there is contrary to it. So if the insolvency code is silent and there is no provision in the insolvency code providing for automatic cancellation of the contract, then the provisions of those valid statutes will continue.
What about section 238?
238 is exactly that. 238 is non-operative overriding effect provided if there is a conflict. If there is a conflict, then insolvency code will prevail.
So that is the question which comes up in such a situation, what Mr. Mandal is referring to, is that on one hand in the resolution plan, it must not have any provision which is inconsistent with any law. How does that operate? Way 238, where there is an inconsistency, and 238 tries to indicate that it is the IBC which will prevail.
Yes, in those cases when the plan comes up for approval and the resolution profession who is presenting the plan includes those clauses in the plan, then the adjudicating authority by its sanctity, if it is brought to the notice, then in the orders which are approving the plan is there is a portion which is set out in the chart. What the SRA has asked for, what he has got.
Yeah.
So in the right-hand column of the order which are approving the plan, with the most of the cases, the adjourning authority writing as per the existing law. So we cannot directly seek a cancellation of the contract,
Or variation of its terms.
because then that will give rise to the question of getting into conflict with the provisions of the Indian Contract Act, because this is an automatic provision. And if there is no provision in the code which provides for this alteration, therefore the provision of the other law will prevail. This 238 only says that where there is IBC has the method, then IBC will prevail compared to other.
So
law.
can we safely advise our clients that fine, your right of termination will be suspended during the moratorium period or the process period. But the terms of the contract cannot be altered to your detriment. Unless
Yes,
the resolution
because once the plan is approved, then those agreements will again come into force.
come into force and it cannot be altered to my
Yes.
detriment. Has there been initial pronouncement on that?
Yes, if it is altered without the knowledge of the contracting party.
Or consent.
Or knowledge or consent, then that party has the right to go for appeal, because he was not aware of it.
No, if it doesn't affect my right, why should I appeal? If it does it affect my right?
Depending, if the contracting party feels that it has affected his right and his knowledge and consent was not taken, and the plan has mischievously altered or tried to deal with or tamper with or change one of the clause of the contract without his knowledge, he can always go and challenge.
Is it a void ab initio clause or is it something which is appealable?
Appealable, because unless it is challenged, the plan has a binding effect, because the plan has.
So then it affects.
Yes, if it is done included without the knowledge of the contracting party.
So it affects the terms of the contract.
Yes, in most cases, some of the cases, these type of clauses are inserted in the plan. Like, for example, other than contract, other clauses are like exemption from getting income tax depreciation benefits, tax benefits, which the judgment of Ghanshyam Mishra has only said that all the liabilities or the demand pay the corporate debtor before CIP stands nullified and we will get on a clean slate. But in some of the resolution plan.
Has Ghanshyam Mishra been watered down, read down, diluted by any other judgment?
No.
But then there is a clean slate, then he takes it on a clean slate.
Yes,
But you have to say something. You
As
have
a
to
third party owner of the property, whatever. When do I get the knowledge that this is happening behind my knowledge? I mean, I
Yes.
don't even have any knowledge.
Yes,
of what
this
is
is
happening, and
the
suddenly you attach my
gray
property.
area. This is the gray area for which what the legislature has not done or should have done. Now there is a notification of 30th January 2020. They just go to it once.
Yeah, you can take.
Yeah. No, where is the first page? If you see, there is this notification of 30th January 2020, but this notification has been published only when a financial service provider like the Reserve Bank of India, because they come under the FSP rules. So when they come under they say that if an FSP or a financial service provider, when they file the Section 7, how do they deal with third-party assets? So where the financial service provider has on the insolvency commencement date in his custody or possession assets owned by customer or counterparty or the counterparty of his customer under a contract and an obligation to return or transfer such assets in accordance with the terms and conditions, the administrator, who is the administrator under the FSP rules, we prepare a statement of such assets and contract, ensure that the assets are maintained in separate, distinct manner capable of identifying their contract file, and return or transfer such assets to the person entitled to receive in accordance with the terms and conditions of the contract. Provided when the assets shall not be returned due to breach of the terms of the contract, FSP has become entitled to retain. So this particular notification which has been published by the MCA has not been published in respect of non-FSP.
Then where does one stand?
So this is the gray area still. Now,
For
for
we
a
not
financial,
advise the clients then should say that this applies only to FSPs.
Yes.
Not to OCs and FCs.
FSP is also an FC.
But not all FCs are FSPs.
No. So they are what the legislature by the notification of 30th January should also have come for normal.
Then
section
no,
7 and
it's okay, presume to know what it is doing. Then has it left out OCs and FCs? from the mischief of this.
No, they are not bothered to cover this grade.
And have they left it out? Have they left them out consciously?
No, not all.
I will say, moderator, why don't you show us to subside?
This, when I was going through this, the first thing which struck me, to be very candid for all of you, the first thing which struck me, I couldn't find any reason as to why this notification will not be applicable to everybody. Or all there is no logic.
However, unfortunately in law, the assumption is that when FCA came out with this notification, it was aware of the provisions of the IBC, it was aware of all the issues arising in respect of the IBC, and despite being aware, chose to issue a notification only in respect of FSPs.
So where does that leave OCs and OFCs?
So-
Other OFCs.
So the question is for Mr. Sharma is that what would be your advice or what would be your views on this lacuna and how to fill it for the benefit of one and all concerned, especially owners of third party assets.
And their legal professionals will advise them.
For this, as so far as the present situation is concerned, because this area is, this notification is not covering a normal section 7 or section 9 case. So according to me, the contracting party who may be the owner of the asset, if his rights are affected, he has to either approach or in the sense be vigilant before the plan is finally approved. Or if in case he is not totally aware or he is kept in the dark or he is not being made aware, then he has to agitate his right before the NCLT. Because either way, he cannot be remediless. Either he has to come up because under sections, the section says that when the plan is put up for approval, everybody and anybody has the right to come and challenge. There is no bar on there is no question of locus or any question of.
However, one question which will come up when you say this is that are we then pushing the owner of such asset towards unnecessary litigation which he ought not to have been aware?
I fully agree to what Mr.
Wouldn't it discourage the owner to? It will discourage the owner to go give for development.
But then, it's fact applied, you have to develop.
It
So
may
forget that,
may not be a
any
question of
any
only
lessee.
the development, can be any other
Any
contract
other
also for use also for maybe for any other purpose, not only development. Suppose the land is given for set up a factory.
Still lease of, aircrafts.
Yes, in aircraft, now they've issued another.
So going into
ahead.
that topic,
Go ahead.
if we could request
Please.
Mr. Sharma to proceed further and into the domain of sovereign assets and.
Yes, now the asset which you can see, the third party asset has been divided into two categories. One may be a sovereign asset, which is being asset owned by a government or any government organization or body. And other is asset owned by a private party. But either way, the asset or the sovereign asset has not been defined in the IBC. And that is IBC Code 2016. So sovereign assets would mean assets like which involve the natural resources which are in the nature of public importance and public nature. These assets, how to deal with those assets. Now this particular issue came regarding when the spectrum.
Aircel.
Now here the issue was whether this spectrum can be included as a part of the. Ultimately, the government said that the ruling came that no spectrum cannot be sold. It has to be excluded. So because it was sovereign assets or natural resources, because the government or the public money or public importance was attached because of public nature, there is a clarity. But in respect of private party assets, there is still no clarity in law.
On the one hand, you're saying that this FSP notification doesn't apply.
No, it does not apply. Because
So non-FSP situation.
Non-FSP situation. Secondly, the SL judgment has also said that no, for government assets and for the spectrum, you cannot include it, it has to be excluded. And now the question is, if during moratorium, so long as moratorium continues, the owner is bound, he cannot do anything. He is helpless, he has to just wait. He cannot terminate, he cannot throw the CD. The moment he throws, then there are many cases which has come up. That during moratorium, no coercive measures can be taken. Now there is just one order which is very surprising. That is the judgment of Balaji,
Bank of India.
no, just one second, because Balaji Forest Products. If somebody has this order, here, there is a particular clause in the plan which has,
Does somebody have it?
Yes, we are.
Will you share this with me?
Who can,
Whoever was writing it.
I'll just send it to them. Let me send.
They sent a message. Sir Balaji,
Yeah, that one. You're right.
yes, Shri Balaji,
Yes.
Forest Products.
NCLT.
Yes, yes.
Mhm.
If you
Yeah.
can see paragraph.
I think it would be for the benefit of the readers. If you could just
Screen share it.
Yeah, not
I'll
put
send
in the
it.
laptop. I cannot find it.
Till Mr. Sharma, it is put up on the screen.
Yes,
If you could also clarify one thing with respect, you mentioned when it comes to sovereign assets
Hmm.
and assets which are of public importance or concern property which is of a public nature. If I'm not mistaken, as far as the SL case is concerned, was there any discussion as to the spectrum forming a part of the resolution plan?
yes, yes.
As long as all government dues are clear. There was a distinction made between the dues pending being cleared and dues not being cleared. So if you could also shed some light on this distinction and how natural would you consider this distinction to be? You bringing in spectrum, which is again you say is or would fall under sovereign asset, being subjected to the CIRP because all dues which were to be paid by the CD has been paid and it not being included within the CIRP because there are dues pending. What happens if someone were to come up and say that, yes, I give an undertaking to clear all dues within a particular time? What would happen then? This, we expect an answer from you, sir, on purely on the principles aspect of it without reference to any particular.
No, in the sale of spectrum in that particular asset, what whether spectrum can be part of the information memorandum and an asset which can be given to a successful SRA. The issue in the SL is that if it is a government or a natural resource or a thing which belongs to the government, when the corporate debtor, the SL is a private company which was getting a benefit of spectrum for doing his business. Now, when SL went into CIRP, the person, the new SRA who came, he wanted to take the CD and run his business. Now, the issue in that judgment order was that whether the new SRA which comes and steps into the shoes of SL and will continue to run the SL as if SL had come out of CIRP, whether it can get the benefit of the earlier spectrum which SL had got. So here the court said no. Spectrum cannot go from one entity to another entity because this is a government. He has to again go and buy. Spectrum will not go. So the question whether regarding payment of dues of that particular corporate debtor was not the relevant issue there. Issue is that if suppose today Vodafone has been always in a very bad shape. And it has been funded many times by Mr. Birla and trying to revive. Thousands of crores have gone into Vodafone. His share price from sometimes go 4 rupees, sometimes 11 rupees. Moment funding comes, it crosses 10, again goes 5. Now today, if we are it has losing customers every day. Most of them have ported, and I have also ported from Vodafone. Now suppose tomorrow Vodafone goes into clarity. Now what will happen? Now Vodafone has many spectrum, many licenses, everything is there. Now Vodafone has paid crores of rupees to get the spectrum. Now that crores, supposing Vodafone has got the spectrum saying, I'm just giving an example, 2005, it had paid 12,000 crores. There is 2G or 3G spectrum or 4G. Now if tomorrow we are in 2024. Now if suppose Jio is participating, I'm giving an example, suppose Jio is participating in the plan of Vodafone. Now Jio will not get the same spectrum at the rate of 12,000 crores in 2024.
Okay.
So that spectrum will not go. to Jio, even if Jio is a SRA and takes over Vodafone.
Is it because of the condition of allotment of spectrum? that the
No,
spectrum
government
is
has said that it is not an
Not
asset, cannot
transferable.
go because
not transferable.
public revenue, because today it is not a spectrum, if Jio gets for 10,000, today the spectrum can charge 50,000 crores.
If it is not transferable, therefore what the point we're trying to make is that the terms of the underlying contract cannot be varied by an SRA.
Yes, but then
But if
if
the government says it was
for
transferable,
for public sector, they have, the laws they have tried to mold it,
separate.
but for the private sector, they have kept it grey, there is no clarity.
But in respect of this process, then it begs the question, since the purpose of the CIRP is to revive the company, you would say that this spectrum would form a part of the critical asset of that company. In fact, there'd be no business without the spectrum. So when you say that you don't get the spectrum, where do we stand? Sovereign asset, critical asset, revival of the company? So what is then the efficacy of this entire procedure? After you have placed or you discussed this particular order, at an appropriate time, kindly do clarify that
Yes, sir.
for our viewers.
No, if the spectrum issue in the asset judgment is on the point that the new entity can come and run the business, but it has to again bid and purchase and buy the spectrum. That is the only sole object of the government. You cannot take over the entity with the spectrum of 2013 and 14.
At those quantities.
Yes, that will not go to you. Only because there being a natural and resource and because public importance and public money is involved, this exception has been carved out. But it is not in other cases, except now they are because of after this Go Air insolvency, there are laws again changed for section 14. There is no notification which has amended that those because this leased out planes and also they will not come on the moratorium. That notification, I think, 3rd October.
Okay, so then following that, the notification of 3rd October, if a leased out asset is not part of company's asset.
No, that is what if you see this, if you just for the moment, just if you can just remove this bar for the time being
on the screen.
and just share the 3rd October notification. The language of the notification is only limited to aircraft maintenance. They are not. They are
Does it apply to
not-
say land? Does it
Yes.
apply to land?
No, nothing.
So if every time there will be case to case basis,
This is
something
what-
like this.
But this was too late. By that time, Go Air has sunk. It will not. It will never come up because by that by say all the leased out planes they have all they come and take over the plane. But the issue came here because they had to bring the notification because they said even you cannot go and inspect. The right to inspection was not given. They went to the Delhi High Court. Delhi High Court.
Just to give a background on the issue which Mr. Sharma is talking about, this happened because Go First, the airline, it chose to go for voluntary insolvency. And once it did, in the course of this process, the lessors who had leased out the aircraft approached the NCLT and said that no, you cannot make these aircrafts a part of the process. That is when this dispute arose, which this notification has come.
Correct.
Share it.
Sarkar is right. Because here the promoter of Go Air is this Bombay Dine. Mr. Wadia. So they filed section 10, they got it admitted. So the moment because lot of dues were there, the banks were chasing. Now the moment it got admitted, now all the lessees and the foreign companies who leased out the planes, they wanted to take back the planes. So they said, no, you have a moratorium, we cannot even touch my planes. So then this 3rd October notification, if you can just see the language, it is only.
That's right. The letter put it in the screen.
No, that's the 30th January.
No, no,
Looking.
3rd
This is
October.
3rd October.
2020.
Yeah, I have it, but
Why
I have to
did you-
log in.
Yes,
Just WhatsApp. I'll just send you.
WhatsApp it to Mahima, then she can sit with the screen.
I got it.
Somebody has to WhatsApp.
I'll just WhatsApp.
But anyway, that again applies only to aircraft.
Yes, they have the language.
Doesn't apply to
If I can
land.
just read the language, I'm just.
So till the time we are advising an aircraft lessor.
See, one has seen. Jet Airways has gone, the plans are approved, nothing has come.
कर दिया ना?
Still the plane will never run.
यही है ना?
If you see the language, it says that not apply to transaction, arrangements or agreements under the convention and protocol relating to aircraft engines, airframes and helicopters. So
Why don't you press that side things on the left? then the whole thing on the left hand side, that.
You have to minimize
Because if this
the
notification had not come,
Uh-huh.
what was happening, most of the airlines, most of them, 99% airlines are manufactured abroad.
Yes,
They would have all stopped leasing to Indian companies. So they had to bring.
so it's a carve out in relation to aircraft only,
Yes.
on the basis of international
Yes.
international convention.
Like most of nowadays, what has happened is most of these PSUs, like this Hindustan Aeronautics, and they are now making this defense equipments are now being manufactured indigenously, like this, so made in India. So earlier regime, most of the defense instruments, the artillery, everything was imported. So now, so if those old regime was still there, if these companies were not them, not there, like HAL is doing very good for last few years. Now, suppose they had, the Indian company had entered into a contract with, say, a Swedish company to buy some defense equipment, like say the Bofors one. Now, if there is a default by Indian company, and then they will say, no, the Indian company has gone into moratorium, so you cannot touch my assets. So if that had been a situation, the similar exception would have come for this defense equipment also.
So that could have been taken back.
Yes. But now most of them in India, they are trying to make this.
All right, fine.
So
Guns and planes apart.
Guns are there is no relaxation.
For the humble Indian.
Humble Indian, you have to fight and get.
So after this, please,
Now, if you can share that part.
Yes.
That's what.
Which paragraph?
So Akshay, who joined late, was in the middle of the negotiation only, where they were discussing third party assets development rights. So Mr. Sharma is throwing light on this aspect.
There are 44.
And just to bring Akshay to speak, he is of the view, basis certain sections of the IBC, that third party assets cannot be harmed in an IBC proceeding. Neither can the terms of the resolution plan affect adversely the owner of the third party asset. But however, if it is terminated prior to the company going into CIRP, it cannot be terminated during the process period. They were an exception recently with respect to aircraft only. In the Go Air case.
You want me to? उसमें आप कहेंगे तो।
Can somebody minimize that thing? Then we don't have to see.
Yeah, yeah. One,
We have to go to that.
I'll do that.
yeah.
But
With 26.
you can indicate the keyword there, you can search and see.
Page 26.
Page 26.
To me, the first words are which, from where do you?
No, I'm just para 44, page 26.
Para 44. Yeah, this is page 20. This is 28, 20.
We come to 29.
Okay.
Yes, see, para 29.
Acha.
Here the land, the factory of the corporate debtor was situated in the land which is not belonging to corporate debtor. So there was some common asset which was in the land adjoining the factory.
Okay.
So here, now like in the Easement Act, we have a right of way. So here, like clause 29, if you can say, any approval with regard to right of way for an unfettered access to the plant is granted. So here the corporate debtor has a factory, but some of these utilities are in the land adjacent to the factory of the corporate debtor, for which he needs access to reach there. Now, this has been incorporated in the plan, and he has got the right to enter into somebody else's property to reach that particular utility which is beyond his property. So this, I am just giving example.
And then you are affecting like the third party.
Yes.
Yes, so this, now this has been included in plans, and this order, see the last one, it is saying granted.
Then how does one proceed?
So this is ultimately then here the permission of the person over whose land the right of way is granted, he is not even aware of it.
Or if he was aware, would have done.
Then he would have
challenged.
Yes, 18 year,
Yes.
2 3 whatever.
Yeah, because if you see if you just see the victory iron
Yes, I
judgment
have
of the
that, yeah.
Supreme
Yeah.
Court, the Supreme Court has said that that explanation A to section 18 of the code exclude assets owned by third party in possession of CD from the scope of 18F and cannot be extended to section 25. So if we read 18, explanation 18 along with 18F along with 25, both use the word assets. If you see 25 2A, the duty of the RP is to take immediate custody and control of all access of corporate data, including the business records. And asset are also being used in 18(1)F.
Explanation.
F uses the word asset, explanation gives the exception. Now, Supreme Court in the Victory Island case has said that explanation A to section 18 of the code. The explanation A means the exception exclude the assets owned by third party in possession of CD from the scope of 18F, and this cannot be extended to sections 25, which places a duty on RP to take immediate custody and control of all the assets of the CD. And therefore, the right of the licensee as against the lessee, noting the licensee does not have any interest in the property and held that enclad and is active batting interest of both parties are protecting the interest of victory in the extent of land occupied and also protecting the possession of CD. So in this particular case, the total land, I think was about 1,000 or something, 100 acres or something. One portion of the land was occupied by Victory, who was the so-called tenant of the owner of the land. So when
Energy.
Energy. So energy by giving the development right to the corporate debtor had allowed a particular portion of the land to be occupied by Victory as a licensee stroke tenant. So when Supreme Court allowed the RP to take control of the asset, Supreme Court did not pass any order that Victory had to be evicted from that portion of the land and left it to be taken steps in accordance with law. So this particular Victory, this judgment has two aspects. One aspect, it has said that development right is an asset of the corporate debtor. That is a final conclusion. Secondly, it has said that if for removing or evicting a tenant or a licensee who is in a portion of the land, that you cannot do under the through the IBC mechanism, you have to take steps in accordance with law.
So in this regard, would you also point out that in respect what the Supreme Court has said in respect of section 18, where for the purpose of section 18 only third party assets are kept out, whereas we see no such letter when it comes to the resolution professional under section 25.
Yes, that is the observation of the Supreme
So
Court.
would you explain to us that part as to why in section 18, when it comes to the IRP, there is an exclusion. When it comes to the resolution professional acting qua section 25, we find no such exception.
The resolution professional basically steps into the shoes of the IRP. So if the resolution professional comes after 3 days of the IRP's appointment, so that is why this exception, because the steps to collect the asset has already been done by the IRP. So if the IRP has done it, so that is why this exception has not been mentioned specifically in 25, because he stepped into the shoe. So in most of the cases, the IRP, some of the cases, the IRP becomes the IRP, some of the cases it is not. So this may be the reason why it's specifically provided. But the issue which the observation of Supreme Court, which I just said, is that Mr. Sarkar has just pointed that the explanation has not been carried in 25 for this reason. Now, Balaji, there is one more passage that I will just show you. The right of easement has been granted under the resolution plan.
Which paragraph?
There is also an entry order which was followed by the Vanguard. Vanguard is paragraph 161. It is
That is a different document. There's a reference made to Vanguard in this order,
Balaji
And it's in the part where it talks about Vanguard. Yeah.
This is expanded. 42 is expanded.
Yeah, this is zoom it. Yeah.
Just go to 41 first. Yes. So here, land is an essential part of CB's business. Entire plant and factory CB is established on the land sought to be transferred to the successor.
Okay, the essence of business, fine.
Yes.
So,
That was, he said, no, you cannot take away the land.
no, during this, what if it is concrete with terms of the contract? What if the contract of relating the land
Yes.
allowed the third party, owner of third party asset to cancel the contract for some other reason, say that he doesn't like the face of the BB or the new TPA, the DSR. Could he cancel the contract post CIR?
And what will happen if say land is affected by ULC? In the permission, government has given a specific condition that you cannot change the management or the shareholders of the company. Now this SRA IBC process,
Correct.
new management and the shareholders. is coming.
IBC will, this plan will override everything.
because when it comes to the, because if one might try to rationalize it, when you are talking about a particular provision of the Urban Land Ceiling Act, where a private person, it is something done in personnel with respect to that person. Whereas once you have a resolution plan, maybe in respect of the same land, it operates in REM, and it is specifically clarified that the central government as also the state government will be bound by it. Even though such clarification perhaps was not necessary, because in REM by itself would mean that it binds the entire world. In fact, this perhaps there is some discussion on this if we refer to the judgment of the Supreme Court in Vidya Drolia's case, 2021 volume 2 SCC page 1.
If you just ensure that whether leasehold right is covered under 18F, that issue is presently pending before the Supreme Court.
Okay. So let's see that.
So it
Which
is,
is,
we have to first take out the enclave New
Neocla.
Industrial
The
Development
encyclopedia. It carries a whole writing.
CLE order.
Pending in the Supreme Court.
You named it, no?
Yes.
Yeah, I'm on-
Now, if you read the last paragraph of this enclave order, the issue is whether leasehold right is covered in the 18F
Okay,
Last
let
paragraph?
her go to the last
of
paragraph.
enclave.
Yeah, I've opened it.
This is Anand Vijay Singh and Sharla.
He was before I'm Singh yesterday. Must have been
Yeah,
a pleasure
this one,
to
huh?
this.
What happened, if I can ask what happened to the previous.
Yes.
He pushed it away.
Final order has not come.
No,
Yeah.
now it's
This is
being
LinkedIn
reheard.
He's.
This is a LinkedIn live, so we
Yeah.
have,
It's on LinkedIn Live, yes.
and then more than 400 people are joining us
22 years,
Then
keeping
what
in
we
view all
discuss
the
private
affordable view of the considered view.
without client consent.
Client.
Yeah.
But we can say that the issue of third party rights is an issue which is peerless as far as with the IBC are concerned.
Kindly see para 22 of this.
That will not be the.
We are the considered leasehold right is an intangible asset of corporate debtor, and the RP is empowered under 18F to take control and custody of any asset over which the CD has the ownership right. We clarified the asset in the instant case are leasehold right and not plot per se. We are also conscious of the fact that substantial development and construction has been carried on a surplus pursuant to the lease deed. The corporate debtor has spent considerable amount of financial resources to develop the said plot, and there is no denial by the appellant that they had shown that they had.
in CA such and such has taken a stand that all risks and rewards incidental to ownership of the subject plot was transferred to the corporate debtor under the said lease.
So this is enclave finding that leasehold right is an asset. Now here very surprisingly, they are using the word ownership right. If a lessee can never be an owner because there is no deed of conveyance within the meaning of the Transfer Property Act. Now, if you see this matter has now gone before the Supreme Court and notice has been issued and this.
Then what happened in this case?
No, there is a distinction made that the asset means maybe moveless or something, but because the next paragraph it is said that we clarify that the asset in the instant case are leasehold rights and not the plot per se.
So land
Yes,
is not
but
going with
Land
the
is
right.
not part of this thing.
Yes, but
Maybe
that-
whatever leasehold right I have under the lease
That was.
and maybe whatever development I have made, I have that right.
No, but
So
then
that
if-
is can be transferred by.
That can be-
Vikram, whatever that iron case.
No, but then
Yeah.
if you have made any construction, suppose sheds, if the land goes, the shed will also go.
No, because lease,
Yeah.
lease,
So
lease
even
may
if,
provide.
even if they use the word not plot, but obviously that if the person has constructed shed, he has constructed labor colony or something. If the land also has to be attached to those.
But normally lease deed provides if you make any development and I take over the land as owner, the lessee may have that
Right
valuation
to
done
remove it,
and
or-
either remove or get the valuation done and get the compensation for the development that he is made.
And this is
But
especially.
that is begging the question that can the SRA through the resolution plan change the terms of the lease? As in say,
As of
within
now,
the-
As of now.
as of now, I don't, as of now, I don't think.
This
Even I
would
don't-
especially
But
become
there is no
relevant
specific-
perhaps.
There is no specific judgment which says it can be done, but that but that the
The
NCLT
lease
plan.
agreement at the end
which
of
is
the
the
day is a
show,
private
Where,
contract.
but their right
Right
of
for
way
third
was
party was
granted.
given.
No, right of,
Private way
that
by-
maybe we have to see that situation because anyway, the existing factory may have that right because
Easement
without that
existing.
right,
Huh.
he may not be
Easement
having
right,
ease with the
easement right.
facilities. He may have existing right.
Easement right has already been considered in Balaji and easement right has also been granted to the SRA.
Yes, sir. So, okay, so easement has been given notwithstanding the consent of the
Yes, no.
third being.
Consent
Yeah.
Unfettered right.
Yeah,
But
he has got the right to access to.
So the dominant heritage is the
Suppose I
right
have
to
to
the
be-
survey
Yes,
heritage.
he has to cross over the land of a third party and go to the.
That's easement of necessity.
Yes.
That is anyway the principle.
Survey heritage, dominant heritage.
So to just bring it into perspective, Mr. Sharma, as we wrap up the session, how would you like to proceed with this discussion so as to bring about some concrete conclusion?
So what are the
on our part?
unanswered issues and what are the answered issues? Which is not covered in law or what is covered in law, which is with third party. So we could summarize this. It has been a fantastic session.
So, according to me, the protection given to sovereign assets, assets of public importance, assets of concerning natural resources like coal, etc. They have been given special privilege and.
That's the carve out of the resolution.
Yes, you can always take them down.
And doesn't apply only to sovereign as owned by the state, but it will also include state with the meaning of Article 12.
Because both. Because, so for example, in one of my matters, I remember that I got an admission order against Eastern Coalfields.
No, the opposite.
I would tend to think that it could also include not only entities which are state within the meaning of Article 12 per se, but a question could also arise whether it could cover entities which are carrying on a public duty
Yes.
per se, even though
Sovereign
not
also.
state under Article 12.
Yes, because any asset which has a sovereign nature or public in
So it's
nature.
the asset, not the entity which
Not the
owns the asset.
entity only,
Yes,
yeah.
correct.
Yeah, but so the sovereign is carved out. Next.
And regarding private entities, the law is still very grey. And
Law is not settled, but it seems that terms of a contract cannot be varied without the consent of the other contracting party because it will be contrary
like
to
following
law
the
under
general
81
labor
years.
principles, which under the old regime. And but the plan nowadays, the plan which have been approved, these clauses are being inserted without the knowledge and concurrence of the
Third party.
According to you, that would be a violation of section 81F.
Yes.
Explanation
Yes,
something?
yes.
Explanation is the
Exception.
exception.
Exception provides the exception.
Hmm.
81F expression says that for bailment or any other contract arrangement, it can be. It is
It
It will not be an.
Not part of the EIA.
81F explanation.
Yes.
But that the problem is that it is not. being
In practice,
strictly-
it is not being followed.
That's what the right is.
So person has to be vigilant. If there is a private contract,
One,
F explanation.
Explanation.
Okay.
One explanation.
It gives an
explanation.
And it shall not include the
A
following.
is
Third party equivalent.
That is owned by third party, those legislature recognize it.
Will not be recognized as an asset. But not because of the,
So how will the third party owner know? Because see, I am a vigilant landlord or owner. But how will I know that something has taken place?
This is the, because when only thing you will know, suppose you have given your asset to entity X. Now then they will say that whenever the orders are passed, it all been published in the newspapers. First order,
Yeah.
recognition order,
Public-
public announcement. Next is the expression of interest comes in the newspaper. Third is
There are judgments where they've not allowed all these extensions and extra things. There are judgments to that also, but then they're all ad hoc. I mean, if you don't cite it, then, or if you're not seeing it, then you don't know. RMB amendments, they've not extended
we
the
have
lease.
to be vigilant there because at every stage public notice is given in the newspapers. Other than
so be
that,
vigilant.
vigilant. Secondly, they said
The
it is
moment you
public-
see that,
See, it is not possible for a owner to go and
Read
check
all the
the-
newspapers.
Not reading, they also post in IBPS site, it's not
Right.
possible for
Correct.
everyone to go and check the
Hmm.
site every day. But they say that every notice is published in the newspaper.
Basically what Mr. Sharma is trying to say that if you happen to be the owner of an asset and you have leased out or you've contracted, you have given out some contractual right to a corporate person, please sleep carefully.
First you choose carefully.
Yeah.
First you choose carefully.
that he will not commit a default in respect of any of his other contracts.
Yeah.
Cannot be of the lease.
So to Mr. Sharma, to just conclude, if you could make out the points that we have discussed, what you think stands resolved, to just reiterate Mr. Mandal, what are issues which have not been resolved? And in short, if you could concretize your suggestions in this regard, as to what perhaps could, or where the solution could lie.
Because as Chambers of Commerce, I am also the chairman of the ICC National Committee of Corporate Affairs. This is my job, my duty as a chairman of the committee, to bring these views to the.
So we have to basically categorize which type of asset are we are dealing with. For example, assets which are owned by maybe a third party but used by the CD corporate debtor. There are some assets which can be owned by a third party, owned by the corporate debtor. There are some assets which are owned by a related party. Assets either hire purchase or lease or as a payment or as a trust. So there are different types of assets arrangement which may be given to a particular entity, which ultimately may go into CLE. So in every case, asset is not asset which is only these. There are other arrangements also. So the course of action will be depending on which type of arrangement the asset is given to the particular business entity for running its business and which type of agreement. There is no universal procedure to be followed. So it will depend on agreement wise and entity wise.
So if a rule had to be made, can we safely suggest that a rule which says that no contract shall be varied to the detriment of any of the contracting parties?
Without his or her consent. There should be a provision like similar to the FSP amendment which they have made.
Which applies to all kinds of assets, every kind of.
Would you also suggest incorporating a provision by which it will become mandatory to personally communicate to the owner of such asset when such a process is thought to be under?
Whoever right is being.
Should have now for this, in this context, if you see the amendment has come in section 79 of the Income Tax Act. Now prior to if we have 79 of the Income Tax Act on screen. Now what happened that this came into this was introduced after this Binani plan was going through. Now Binani has huge income tax about more than 20-30,000 crores. Now Binani was taken over by Ultratech, even now Ultratech, Nagpara, now everything is happening. Now here the income tax demands were huge, and under the Insolvency Code there was no method, there is no procedure to inform the concerned authority. Now, the entire plan was approved, everything was done, and then income tax authorities woke up from the slumber and they started approaching, filing writ petition in various high courts all over that we have so many demands because Binani had a lot of plants in Rajasthan, Delhi, some in yeah. So wherever the plants were there, they were going.
So what is the change?
The change, if you have, I don't read, so if you expand it, there is a particular provision that
You
says
can,
No,
that,
this
you can
is-
see the screen here.
but there is a clause which says that you have to.
No, this
the
has been
income tax,
amended,
they have to be
Mahima.
noticed.
Don't go to Indian Kanon.
Then it'll take.
Income tax.
So if you could just explain
That
to us.
now the amendment that says that before any plan is approved,
Hmm.
a notice has to be given to the concerned jurisdictional income tax commissioner, not person below the rank of commissioner. He has to be given notice before the approval of plan, and the satisfaction of service of notice should be mentioned in the Form H, which is filed by the RP. So this will show that once this how much exemption, how much allowance, how much waiver of tax liability.
Okay, so but the same rule doesn't apply in respect of third party assets.
Yeah.
Because third party
Or
assets
also
are
for GST authority also it doesn't have.
Hmm.
Who has,
GST
who has
authority?
notified.
No, they are equating natural justice with like Mr.
Sarkar.
Sarkar said section 12. Or
Yeah.
Article 12, sorry, Article 12.
Mr. Bhagat is talking about GST. What about GST?
GST is still, GST is under same Ghanshyam Mishra.
It can be amended.
Hmm.
Income tax, there is only section 17.
Clean slate.
Ghanshyam Mishra clean slate. Income
This is
tax.
required to be given to.
No,
GST.
what they are
Like a
doing,
washing
now,
machine.
most of the resolution plans, they are saying we have complied with section
Section.
79. But
What about the other third parties?
only 79 of income tax has been amended.
So the only thing
because-
which helps, which saves us, Mr. Moderator, which I think Mr. Sarkar has, Mr. Sharma has with lot of clarity, focused on is that 18(1) explanation A. Says that such an asset of a third party cannot be part of the asset of the CD.
Hmm.
Therefore, it cannot be part of the RP resolution.
Correct. Correct. So just to draw a conclusion, we've had a very illuminating discussion in respect of a dark subject matter as far as the IBC is concerned. But as we can understand, we are here moving from problem to problem, from solution to solution. As and when a problem is being detected in respect of a particular facet of this third party right issue, we see solutions come about. But what Mr. Sharma suggests, and I should hope that our viewers would also agree, a solution which would take within its fold as many facets as possible is perhaps the need of the hour. I thank Mr. Sharma that he has shed light on this issue as he has done in the course of his advocacy and because of his involvement in several high-stake matters. He has given us, I would use only one word for it, he has given us some hope that all is not lost. There are problems and there are solutions. It is only a question of having the will to find that solution and to give effect to it. I hope we've all enjoyed the session. I certainly have. I thank Mr. Dhiren Sharma and I thank all the participants who joined today's session, or this evening's session. And in particular, I will thank Mr. Deepan Kumar and Mr. Kunal Vajani and all the other functionaries of Fox&Mandal for having organized this session for us and for our benefit. Thank you very much. Have a good night.
Thank you, Mr. Sharma, thank you very much. Now, let me invite Ranjit Bedi. You would like to propose a vote of thanks.